Ready, start. Learned counsel for the respondents supported the impugned order. According to him, the High Court was justified in exercising review jurisdiction by issuing a direction to recompute the cut-off marks and thereafter hold an additional main examination. It was undisputed that all candidates, irrespective of their eligibility in accordance with the rules of 1994 as amended, had been permitted to appear in the preliminary examination. As a result of the participation of such candidates, the cut-off marks had been determined. The respondents, though eligible for appointment, were being deprived of an opportunity to appear in the main examination only on the ground that they did not obtain the requisite cut-off marks. After the names of the ineligible candidates were deleted, the cut-off marks would be lowered down, thus entitling the respondents of having an opportunity to appear in the main examination. The appellants proceeded on a misconception that the cut-off marks were sacrosanct and irreversible. There was a distinction between the eligibility criteria and prescription of cut-off marks. The fact that 194 candidates were found eligible after recomputation of the cut-off marks indicated the error that was committed by the High Court in its order dated 7/5/2024. Since the High Court had conducted a second main examination for physically impaired candidates, there was no reason for not conducting another main examination for candidates who were otherwise eligible and entitled to appear for such examination on the basis of the recomputed cut-off marks. It was thus submitted that the High Court did not commit any error in exercising review jurisdiction. Hence, no interference with the impugned order was called for and the appeal was liable to be dismissed. We have heard the learned counsel for the parties at length. We have perused the documentary material on record and also considered the various decisions relied upon by the learned counsel for the parties. In our view, the impugned order dated 13/6/2024 passed by the High Court in exercise of review jurisdiction is liable to be set aside on the ground that the High Court exceeded its jurisdiction while reviewing the earlier order dated 7/5/2024. It is seen that in the writ petition preferred by the respondents before the High Court, a challenge was raised by them to the results of the preliminary examination declared on 10/3/2024. The respondents also prayed that the marks be re-evaluated in accordance with the new eligibility criteria and the results be revised accordingly. When the said writ petition was decided on 7/5/2024, the validity of Rule 7 of the Rules of 1994 had been upheld by the High Court in another batch of writ petitions decided on 1/4/2024. The respondents contended before the High Court that as the validity of the amended rules had been upheld, there was a likelihood of scrutiny of all candidates before publishing the final list. As a result, it was likely that the respondents who had not secured the cut-off marks would have an opportunity of achieving the benchmark after recomputation of the cut-off marks.